Wi-Fi connected to.
We're live.
Okay, thank you. Okay, we are back in Senate institutions on February 13th, and now we are going to do a walkthrough of a bill we just received today, S69, which is protection of personal information and privacy of minors. And we have Rick Siegel to Ledge Council to guide us through this walkthrough. So with that, Mr. Siegel.
Good afternoon. It's actually Stable.
Stable.
I always say
Excuse me?
Bagel like bagel. That's
Bagel and bagel, and you've said that before.
it's
Okay.
hopefully helps, but otherwise it looks like it.
It'll help. And I think you know everybody, right?
Yes, yes. So Rick Stable, Office of Legislative Counsel. I'm going to share my screen here. So if I read this bill word for word, it would take 30 minutes, and I don't really want to just read to you for 30 minutes. Y'all can read the bill and, of course, follow up with me with questions, but I will kind of go through and read some of it word for word with a couple of notes here. This is a very technical bill. It's a very dense bill. It has terms that are, you'll see the word algorithmic. You'll see the word biometric data. It's very, very techy. So, and a lot of this bill is not my language. It came from various groups suggesting what should be in here, how it should be worded. People much smarter than I am who know the issues with online privacy, those kind of things. So with that said, you're going to have a lot of questions about this bill. And you're going to say, hey, Rick, why is this in here? I'm probably going to say, I don't know.
You won't always say that.
No, but the intent is not going to be, but you're going to have witnesses come in and explain, this is why we want this language. This is going to help us X, Y, Z. Certainly words on the paper. I can help you understand this is what this does. And this is what this will do. Just kind of giving you, I won't do this for every bill that I come in here for, but this one is going to be one that's going to be a little bit, I don't use the word complicated, but it is a little bit different.
Thanks for the heads up.
It's also half of its definitions, which should give you an idea of what we're getting into here. More than half its definitions. Okay, so with those disclaimers, I will start. It's actually page 2 where the legalese begins. And we define affiliate. This one you know about. You should know the word affiliate, I assume. It's just a legal entity that shares common branding with another legal entity. And we include that here because this applies to businesses. Businesses sometimes use affiliates instead of their own name brand. So you can see here what this means. Nothing controversial, nothing tricky about the definition of affiliate. Definition 2, age assurance, encompasses a range of methods used to determine, estimate, or communicate the age or an age range of an online user. This will become important later. I'll note that. Algorithmic recommendation system means a system that uses an algorithm to select, filter, and arrange media on a covered business's website for the purpose of selecting, recommending, or prioritizing media for a user. Another kind of injection here. You'll notice that these definitions often have other words that are yet to be defined in here. So, for example, covered business is a defined term that I'll get to here in a second. Biometric data, or A, means data generated from the technological processing of an individual's unique biological, physical, or physiological characteristics that allow or confirm the unique identification of the consumer, including, and you'll notice these are all very personal things that people have. And the argument is these should be, this type of data should be private and is very sensitive. I'll let you look over that. Subdivision B, biometric data does not include a digital or physical photograph, an audio or video recording, or any data generated from those two things, unless such data is generated to identify a specific individual. Okay, so subdivision 5, business associate, has the same meaning as in HIPAA. HIPAA is involved in this because of consumer health data. Get to that later.
Do we define HIPAA somewhere?
I don't believe we do.
Or like spell it out? It just seems like we should.
Or reference the actuals. Right. No, I'll note that we may need to at least, say the health information, privacy, etc. 6, collect means buying, renting, gathering, obtaining, receiving, or accessing any personal data by any means. This includes receiving data from the consumer, either actively or passively, or by observing the consumer's behavior. Compulsive use means the repetitive use of a covered business's service that materially disrupts one or more major life activities of a minor, including sleeping, eating, learning, reading, concentrating, communicating, or working.
This is a really interesting definition. That's
So this is narrow, I mean, because and it covers just minor there, but I mean, compulsive use could be any.
Right. So this bill is specific to minors. Consumer is an individual who resides in the state. However, it does not include an individual in a commercial or employment context, as an employee, director, officer, or contractor of a company, partnership, sole proprietorship, et cetera, government agency, whose communications or transactions with the covered business occurs solely within the context of that individual's role with the company, partnership, et cetera. Consumer health data means any personal data that a controller uses to identify a consumer's physical or mental health condition or diagnosis, including gender affirming health data and reproductive or sexual health data. Controller means a person who, alone or jointly with others, determines the purpose and means of processing personal data. Okay, this one's important. Covered business, they're all important, but certain ones are going to be used more than others. Covered business means just about everything. It's a sole proprietorship, a partnership, a LLC, corporation, association, other legal entity, or an affiliate that conducts business in the state and whose online products, services, or features are reasonably likely to be accessed by a minor. And that A, collects consumers' personal data. Note that it's not minors' personal data, it's just consumers. So we're not just limiting it to minors when it comes to data, or has consumers' personal data collected on its behalf by a processor, and alone or jointly with others determines the purposes and means of the processing of consumers' personal data. So right there, you're really narrowing the scope of what a covered business is. You can have this big reach of every business in the state, except just these businesses that collect consumers' personal data and alone and jointly with others determines the means and purposes of processing that data. Does that make sense? Yeah. It's very, very narrowing the scope. The covered entity has the same meaning as in HIPAA. A covered minor is a consumer who a covered business actually knows as a minor or labels as a minor pursuant to age assurance methods and rules adopted by the AG, which we'll talk about later. Default is just a pre-selected option selected by the covered business. The identified data, pretty lengthy definition here. I'm not going to read this whole thing, but it is data that has been removed of its personal information. It cannot be reasonably used to infer information about an individual or identifiable individual or a device linked to an individual if the covered business that processes the data does these two things. And I'm not going to read this. I'll let you all read what that de-identification process looks like.
And Rick, just before you jump off of that, this definition is similar to the definition in HIPAA. Is that correct? Or don't you?
I don't know. I can check on that for you.
It seems familiar.
Okay, going down to the next page, number 16, derived data means data that is created by the derivation of information, data, assumptions, correlations, inferences, predictions, or conclusions from facts, evidence, or another source of information or data about a minor or minor's device. Genetic data, I'm not going to read this one, but you can see what is included: DNA, RNA, things that are related to genealogy and genes. 18, identified or identifiable individual means an individual who can be readily identified directly or indirectly including by reference to an identifier, such as name, an ID number, specific geolocation data, or an online identifier. We're almost halfway through the definitions here. Known adult is a consumer who a covered business actually knows is an adult or labels an adult pursuant to age assurance methods and rules adopted by the AG. A minor is an individual under 18 who is a resident of the state.
There, can I ask you a question here? In the previous bill, we had different thresholds for different ages. Is 18 the only age that we have thresholds for in this bill?
No, I think what you're referring to is coming up.
Okay.
A neural data is information collected through biosensors, and that could be processed to infer or predict mental states. That's a fairly new type of thing. If you're curious what neural data is, I'd encourage a little bit of research of what that looks like. 22, online service, product, or feature means a digital product that is accessible to the public via the internet, including a website or application, and does not mean any of the following. So again, we're kind of narrowing the scope here. We do not include a telecommunication service. That would be your cell phone providers, your big telecommunications companies, broadband internet service, or the sale, delivery, or use of a physical product. So if your company just sells widgets at a store, you're not going to be lumped into this bill unless you also process data. But 23A, personal data is information, including derived data and unique identifiers that is linked or reasonably linkable to an identified or identifiable individual or to a device that identifies or is linked to the client. Personal data does not include de-identified data or publicly available information. This is a pretty big exception here. I'll define public available information in a second. Precise geolocation data is information derived from technology that reveals your past or present physical location within an accuracy of 1,850 feet. Why 1,850 feet? That appears to be the industry standard for this these days. We all know it's much closer than that, I think. Our phones know where we are. Precise geolocation data does not include, on page 8, the content of communications, data generated by or connected to an advanced utility metering infrastructure system, a photograph or metadata associated with a photograph or video that cannot be linked to an individual, or data generated by equipment used by a utility company. Process or processing is just a set of operations on personal data. If you look at that one, processor means a person can process this personal data on behalf of a covered business.
Mr. Siegel.
Yes.
But I'll call you Mr. Big. That's gonna be
That'd be okay.
fun. When we did this previously, I think it's a processor versus a controller. Can you explain typical relationships between processor and controller?
So a controller determines the mean of how data is processed, typically oversees the processor. They can be within one company, one organization. You can have a data controller operation and data processor operation. They can sometimes be the same organization that does both. But the controller controls the means of processing data, while the processor just actually processes the data. Much more technical function of the processor.
So the processor would be a company on the internet or that deals with internet. The controller might be a business. But is it possible to give a real life example?
I would encourage witnesses to give you real life examples of what that looks like and how they would be affected. And
like a shoe store, I think would be.
a shoe store that, do they have a loyalty program?
Yes.
So that's kind of where you start getting into like what a processor and controller is. You know, these programs, point of sale systems, sometimes you can use Stripe or Apple Pay. Like, so these things get fairly complicated. I don't want to misspeak about,
Okay.
you know. But
Okay, but that's just a really important distinction.
It is.
That when we look at this.
So would the processor be this third party?
Usually it's a third party.
Yes, okay.
As
So-
as a controller, they're both usually third parties.
Oh, the controller as well.
Yes.
Because I'm thinking of the third. So I run a house club and I have a third party do my data processing as well as my billing. They be the processor.
Yes, in that case, I think you'd be the controller and the processor.
That's what
Yeah,
I.
that's how you're managing
Yes.
your business.
Yes, okay.
Good example.
Thank you.
Yeah, I would encourage testimony. You'll get testimony from organizations that will explain the distinction and they may request certain changes or. 27, profiling is any form of automated processing performed on personal data to evaluate, analyze, or predict personal aspects related to an identified or identifiable individual's economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. Okay, so publicly available information is another important one. Means information that is made available through federal, state, or local government records, or a controller has a reasonable basis to believe that a consumer has lawfully made available to the general public. Now, we have a lot of exemptions here, because remember, publicly available information does not get lumped into this personal data. So, if you say something that's publicly available information, that's not protected data in this bill. So these exceptions would imply that these are included as personal data that should be considered when processing. 1, biometric data collected by a business about a consumer without the consumer's knowledge. Information that is collated and combined to create a consumer profile that is made available to a user of a publicly available website, either in exchange for payment or free of charge. Information made available for sale, inferences about the previous two, and an obscene visual depiction. I don't have that. There's the code there. You can look what that looks like in the US law, federal law. Any inference made exclusively from multiple independent sources of publicly available information that reveals sensitive data. And we define sensitive data here in a second. Personal data that is created through a combination of personal data with publicly available information. Genetic data, unless otherwise made publicly available by the consumer. Information provided by a consumer on a website or online service made available to all members of the public for free or for a fee. Where the consumer has maintained a reasonable expectation of privacy in the information. Or intimate images, authentic or computer generated, known to be non-consensual. Okay, reasonably likely to be accessed on the next page. It's a service that is reasonably likely to be accessed by a covered minor based on any of the following indicators. It is a service directed to children as defined by COPA. That is a child protection law passed by the federal government in the 90s. The online service product or feature is determined based on competent and reliable evidence regarding audience composition to be routinely accessed by an audience that is composed of at least 2% minors 2 through 17 years of age. So now I'm sure that's what I think you may have been thinking about this, where you have the age.
Yes. Yeah.
The age differences. The online service product or feature contains advertisements marketed to minors. The audience is determined based on internal company research to be composed of at least 2% minors 2 through 17 years of age, or the covered business knew or should have known that at least 2% of minors. The audience was 2% minors.
Yeah.
In making this assessment, the business shall not collect or process any personal data that is not reasonably necessary to provide an online service product or feature with which a minor is actively and knowingly engaged.
So we'll get testimony, excuse me, about what. This actually is not the one I was thinking of, but it's interesting that it's an audience that is composed of at least 2%. Basically 2% of the people are minors 2 through 17 years of age. I mean, the audience changes, so it's got to be some sort of average, for over a period of time.
Yeah.
So
It's what they thought, what they reasonably should have known. So if they change their app to be an app that's 12 plus or mature, then that would maybe change the users that are using the app, and they should have known Or if they change it from if they lower it to a lower age, they should know that will change the legislation.
Okay, thank you.
Sensitive data is data that reveals a consumer's government ID or some other social security number, passport number. Reveals a consumer's racial or ethnic origin, national origin, other protected classifications. C, reveals a consumer's sexual orientation, sex life, sexuality, status as transgender or non-binary. D, reveals the consumer status as a victim of a crime. I'll let you all read the rest of these. Again, these are just what's considered sensitive information you would not want a processor to process or a controller to tell a processor to process. G, let's see, that's consumer health data. Yeah, we'll let you read those and see if you have any questions. Definition of social media platform on line 9 of page 12 means a public or semi-public internet-based service or application that is primarily intended to connect and allow a user to socially interact with such service or application and enables the user to. So I think we all kind of know what a social media platform is. This just, obviously we have to define it. We don't want to bring in a company that maybe a small portion of their business is social media, but clearly Facebook, Instagram, these kind of companies would fall under the definition of a social media platform.
Is there a number on that?
31A?
No, is there a numerical quantity of users?
No, it's just primarily intended to, if you look at the per line 10, primarily intended to connect and allow you to. Yeah.
Okay. So that's their main business.
Yeah.
Operations. That's the same thing.
At the bottom, a social media platform does not mean a public or semi-public internet-based service or application that exclusively provides email or direct messaging services. Primarily consists of news, sports, entertainment, interactive video games, electronic commerce, or content that is pre-selected by the provider for which any interactive functionality is incidental to or dependent on the provision of such content, or is used by and under the direction of an educational entity, including a learning management system or a student engagement program. And then third party is a pretty easy definition. Also going to add that this language has been looked over by so many different groups that it's not the easiest to read, right? And it's maybe complex, but that's usually because so many groups are wanting to ensure that language protects them or ensure that everything is covered a certain way. Okay, exclusions. This subchapter does not apply to any state, federal, local government entity in the ordinary course of its operation. Pretty big exclusion there. Protected health information that a covered entity or business associate processes in accordance with or documents that a covered entity or business associate creates for purpose of complying with HIPAA. Information used for only public health activities and purposes. Information that identifies a consumer in connection with, here you have some more federal health actions that there's been suggestions we don't include these groups in the bill. So A, B, and C are all consumer health data related. D is what, excuse me. And 5, an entity whose primary purpose is journalism, as we define in our statutes, and that has a majority of its workforce consisting of individuals engaging in journalism. I think the idea is there, if you have an online newspaper that has comments or they allow people to register, that's not considered a covered business. Okay, minimum duty of care. So a covered business that processes a covered minor's data in any capacity owes a minimum duty of care. What does that mean? It means the use of the personal data of a covered minor and the design of their service will not result in reasonably foreseeable emotional distress, as we define. And if you look at that definition, it's pretty severe. emotional distress. You can look that up, but that's, pretty bad distress. 2, reasonable, foreseeable, compulsive use of the online service, product, or feature. So earlier, that definition of compulsive use is important to note. 3, discrimination based upon certain protected classifications. C, the content of the media viewed by a covered minor shall not establish emotional distress or compulsive use as those terms are used. So this language is intended to ensure that just because a minor views content that they may have requested does not mean the covered business is responsible for showing that content to the covered minor. It has to be more than just the content viewed by the minor. It has to be the design of the service. It has to be how the service is actually functioning that creates that compulsive or emotional distress. D, and this is kind of following up with what I just said, nothing in this section shall be construed to require for the business to prevent or preclude a covered minor from accessing or viewing any piece of media or category of media. This is the First Amendment type of protection.
Okay, so question.
Yeah.
So this is where, I just want to make sure that compulsive use is a definition. And it's at a lower threshold than the one that's already in statute, the emotional distress.
Oh, well, we define compulsive use in this bill.
Right, so I would just double check, that's why I didn't hear everything that you just said.
Yeah. So the emotional distress, if you look in that statute, it's a very severe type of distress. It's not just you're depressed. It's not just you're sad. It's causing physical issues.
Bless you.
There's connects if you want. But then we also say compulsive use, which is at a lower threshold.
Yeah, and you can see I have it up on the screen. Materially disrupts is kind of the standard there. So, what kind of features would cause a minor to not be able to concentrate or communicate materially, right? That's something you might want to hear testimony on.
Right. But is this the part of the bill that talks about the algorithms rather than the content?
We're getting there.
Okay, but this excludes the content.
So
Thank
let me go back down where we are. This is just the C and the D are just ensuring that minors, if they request the content or if they view content, the covered business can't be liable for that.
Cannot be liable.
Yeah, because minors have the right to speech as well as adults do.
Okay. Thank you.
Okay, 2449D, require default privacy settings and tools. This one's actually a little easier to understand. I'll just kind of put that out there. A covered business, you only need when you download an application on your phone or access the website, there are kind of default settings for you that you can change. So this bill would require the following to be default when you actually register with the website or with the app. When you create the account, it would require these settings be by default. A, not displaying the existence of the covered minor social media account to any known adult user unless the covered minor has expressly and unambiguously allowed a specific known adult user to view their account or has expressly and unambiguously chosen to make their account's existence public. B, not displaying media created for this. I'm going to stop there because it's the same exact ending that unless they specifically allow that to happen. C, not permitting any known adult users to like, comment on, or otherwise provide feedback on the covered minor's media unless they have expressly and unambiguously allowed that to happen. Not permitting direct messages unless they have expressly and unambiguously allowed that to happen. Not displaying their location to others unless they've agreed to do that. Not displaying their connections, the user's connection to them, unless they have expressly and unambiguously chosen to do that. Disabling, your question?
So not displaying and not permitting, but But, so on line 14, just not displaying the covered miner's location. I think somewhere else, there's something about not sharing and not providing,
Tracking,
yeah,
yes,
the
yeah,
information. It's not just not displaying.
right.
Okay,
This is more about just the terms with the company, and when you register, these are your default settings. You can
Okay.
change them, but these have to be the default settings.
that's great. Okay, great. Thank you.
Disabling search engine, G, the search engine indexing, of the covered miners account profile. And H, not sending push notifications to the covered miners.
Which is one of the algorithms that causes various levels of distress.
Right. And again, the covered miner can choose to change that to receive push notification. I think in fact, a lot of apps require you to allow that to happen first before they can do it. But in law, this would say you have to actually let them opt into that. Okay, 2, a covered business shall not provide a covered miner with a single setting that makes all the default privacy settings less protective at once. So you have to have several checkboxes to agree to those things. Or request or prompt a covered miner to make their privacy settings less protective unless the change is strictly necessary for the covered miner to access a service or feature they have expressly and unambiguously requested. And then on the deletion, a covered business shall basically make it easy to delete their account and honor that request 15 days after they receive the request. So they can't hide the delete account button. It's going to be prominent, accessible, responsive. We are past the time. Should I keep going?
No, you please go.
Okay.
Yeah, no,
Okay.
I don't think we're,
I had 3:45, so making sure we're
oh,
still
okay.
in.
Thank you for your consideration.
Transparency 2449E. A covered business shall prominently and clearly provide on their website or mobile app the privacy information, terms of service, policies, community standards, detailed descriptions of each algorithmic recommendation system in use by the covered business, including the factors used by the algorithmic recommendation system and how each factor, you can read those. You'll probably get some pushback on that. The algorithms tend to be, I don't know if they're trade secrets, but they tend to be pretty protective of
Yeah.
how their algorithms work. 3, descriptions for every feature of the service that uses the personal data of covered miners. Again, this is just they must provide in their policy how they use the data. Okay, 2449F. This was not in the Kids Code bill last year. This is more of a data privacy type of aspect to miners' data. The data privacy bill did have a section on miners' data privacy. But because that bill didn't go through, it's now in this bill as far as just miners' data privacy. Okay, data privacy. A covered business shall not collect, share, sell, or retain any personal data of a covered miner that is not necessary to provide an online service product feature with which the miner is actively and knowingly engaged. Use previously collected personal data for any other purpose than which the purpose was for which the data was collected, unless necessary to comply with any other obligation. Permit any consumer, including a parent or guardian of the covered miner, to monitor the online activity of a covered miner or to track the location of the covered miner without providing a conspicuous signal to the covered miner when the covered miner is being monitored or tracked. That's what I think what you're referring to earlier. 4, use the personal data of a covered miner to select, recommend, or prioritize media for the covered miner, unless the covered miners express an unambiguous request to receive the media, more or less media, a specific category of media, and this might be the first time we have these phrase cat videos in a bill. Breaking history. I hesitated to put that in there, but they really wanted that phrase. But now you know what they're referring to, specific category like cat videos or breaking news, or more or less media with similar characteristics as the media they are currently viewing. Again, we're talking about using personal data to of a covered minor to select, recommend, or prioritize media unless, okay, unless the personal data is B, user selected, privacy or accessibility settings, or a search query, provided the search query is only used to select and prioritize media in response to the search. 5, send push notifications to a covered monitor between midnight and 6. So even if you allow notifications, you would not be able to send these notifications between that time, midnight and 6 a.m.
So what was the determination of those times?
What was the one? Sorry,
Why did they want those times specifically? Is it because it's when people are sleeping?
that's my guess. Yeah,
Yeah.
more of an intent question. I wouldn't be able to tell you what they were thinking.
Yeah, we'll get.
Yeah, because honestly, like, I don't think push notifications are great to pick anyways, because they're intended to get you back on the app. So they got findings entirely as far as I'm concerned. But, sorry.
No, that's right. And then rulemaking, there's a lot of rulemaking here. I'm going to point that out. Giving the Attorney General quite a bit of latitude to, fill in the gaps of what the legislature didn't do. The AG shall have the authority to adopt rules that prohibit data processing or design practices. So I'm going to take a step back for a second. We just went over quite a few things that are mostly data privacy related. There wasn't a whole lot design related. So you're giving the AG the authority to basically, and you can see the next sentence, I should have kept going, lead to a compulsive use or subvert or impair user autonomy, decision-making, or choice. So the AG is given fairly wide latitude to kind of come up with rules that these covered businesses would have to abide by when they're designing their app or website. The AG shall, once every 2 years, review and update these rules as necessary. We're almost done. Age assurance. So remember, this whole bill is about covered minors. How does a business know if their users are minors? Well, they have tools that give them estimates of how old their users are. There's different ways of doing it. Covered businesses and processors shall only collect personal data of a user that is strictly necessary for age assurance. And immediately upon determining whether user is a covered minor, delete any personal data of that user for age assurance, except whether or not they are a covered minor. Now use that data for any other reason, not combine that data with any other personal data of the user, except, again, if they are not a covered minor. And implement a review process to allow users to appeal their age designations. So you're allowing the covered businesses to use these tools to determine how old their users are, but then once they use those tools, that data must be deleted, except how old they are. That's the only thing you keep on them. You are also, here's more rulemaking, you are giving the AG authority to adopt rules that identify commercially reasonable and technically feasible methods for covered businesses and processes to determine if their user is a covered minor. And again, giving an appeal process to them. And they should also update those rules as necessary to keep pace with emerging technology. You are giving the AG some guidance here. They shall prioritize user privacy and accessibility over the accuracy of age assurance. They should consider the size, resources of businesses and processors, the cost and effectiveness of available age methods, the impact of these methods on user safety, utility, and experience, whether transparency measures would actually increase consumer trust, and the efficacy of requiring these businesses and processors to use data to determine age, to adopt interoperable age assurance methods, and provide users with multiple options for age assurance. Enforcement, if a business or processor violates the subchapter, they fall under the Vermont Consumer Protection Act, which is in 2453 of Title IX. The AG, we gave them kind of specific rulemaking. Okay, they can also have kind of more broad rulemaking in general to this subchapter. Just because you don't say something specific in this bill doesn't mean they can eventually make rules that are otherwise mentioned in the bill text.
So, can you please explain, and I know we're running late, but this is just really important, the right of private action in last year's bills, a couple other bills were of great concern. And that type of right of private action is not in this, but there is another type of right of private action. So could you
Right.
explain that?
I sure can. It's a topic du jour, I think, the private action. So whenever you see this language that, an unfair and deceptive act of commerce, this pulls in the Vermont Consumer Protection Act, which I think was put in the sixties or seventies. It's been around a long time. The intent is that this type of law is something that is consumer protection oriented, and that if a business violates it, that is a deceptive act, fraudulent act, and gives not just the Attorney General authority, as you see in subsection B, but also people, individuals. So if you have been harmed by the processing of your personal data or the design of a product that has caused you severe emotional distress, you'd be able to use this bill if it passed, and hold the business accountable under the Vermont Consumer Protection Act. And so there have been other bills where you actually call it out and you say there's a private right of action. And usually that's done because you are kind of clarifying when they can do that. Maybe you say that only certain covered businesses are eligible to be held accountable under the private right of action. Here, it's much more common to do this though, to just call into effect the Vermont Consumer Protection Act and let that law speak for itself. Does that help?
It does. I think we'll just get more information on that because that's just really important for us.
And the punishment, I would suspect, would be monetary,
Yes.
from fine from the Attorney General, suits from individuals.
So if an individual sues, it would be monetary. You might be able to get an injunction for them to stop doing this thing. But likely the reason you're suing is to get some type of compensation. And just adding on the Consumer Protection Act does allow the treble damages. And that's kind of the reason why. It's meant to be, this is a deceptive act and there should be a penalty. That's the idea behind it.
Okay. I think, I'm sorry, I probably cut you off.
There's just,
We got the rights and freedom.
two more pages, yeah, 1.5
Okay.
more pages, limitations. The imposed liability that is inconsistent with 47 USC. That is a federal law that says, I'll give you an example. When you leave a review on Yelp, Yelp is not responsible for the content of your review. So meaning like they can't be held for like defamation, that kind of thing, right? They may be asked to take the review down because it's inflammatory or defamatory, but they can't be held monetarily liable. So in this case, what we're talking about is that no covered business should be responsible for content it's hosting on its platform if that content is somehow inappropriate or inflammatory. Or to prevent or preclude any covered minor from deliberately or independently searching for or specifically requesting any media. This again is the First Amendment, making sure they can access what they want to access. And the last section is just ensuring that nothing is meant to infringe on the rights and freedoms of covered minors or just be held to discriminate based on a covered or protected classification. And note the effective date, July 1, 2026. I think the thought there is to give companies enough time to update their terms, their privacy settings, default settings to comply.
Great. Senator Andrews.
Thank you. Counselor, I don't want to take too much more of your time. And thank you for doing that, but is there anything in this bill that's going to actually protect the business? We get a minor on here, bypass everything that they can do and still go, how does that business know that they're interacting with?
So if a minor, let's say, creates an account on an application and they become a user, are we saying they basically abide by what the company's doing. The company's correct, that they're providing the default settings the right way. Their terms are correct, but the minor is,
It's the system, I can,
Yeah. So if the covered business has done its job of having the default settings a certain way, not allowing a minor to be contacted by an adult, then they're not in trouble as long as they do X, Y, Z. So the minor, and that's kind of clear in the bill that we don't want to stop the minor from doing that. If they want to access the content, if they want to allow unknown adults to contact them, see their friends, they can do that. They just have to choose to do that expressly and unambiguously, is the phrase of the bill.
wow. This is dangerous.
But real estate is excluded from, it's in the protection.
Radio.
Oh, interesting. That's gonna be a good perspective.
Yeah.
Okay.
But you wouldn't be
No,
a social
but,
media.
no, well, yeah, I will be actually, because that's what we are gonna be. We're gonna be a radio company. Then we're gonna be an advertising company that plays darn good music, but we are going to be advertisers. We're going to be, that's what we're gonna be. And so if you have somebody that still keeps on just bypassing everything that you are, because unfortunately, these devices, they don't have a warning label like an ID saying, hey, this person isn't of age, but yet they keep on continuing and they keep on acting like adults. They keep on doing adult acts. And in real life, they actually can be in trouble for continuing to do adult acts as they move forward. But here I see no protections that can happen. You know, they're not, the minor isn't doing anything that is prohibited to them, but yet they're acting like an adult and they have all the protections of a minor, but they're trying to do adult thing. It's a slippery slope that we're gonna go down through here. And, I'll be curious to have a lot more discussion about it.
Great.
Yeah,
And if there's any witnesses you want to hear from particularly.
that's nothing.
So
It's probably a lot.
I appreciate you because, in that, a little discussion there, you were absolutely Switzerland.
What? Switzerland? Is that, yeah.
Yes.
Okay, beautiful.
That's
Yes.
what
That's my job.
Yes.
That's my job.
No, I think it's, yes.
And it's important to be that way. I mean,
No, it is.
you all are the decision makers, and I'm here to help you with a confusing term or what's been constitutionally challenged. And again, this is a fine line. Like some of these things, as we get into it, you'll hear not maybe from me. Eventually, you may hear from me. But these bills are getting challenged. Not so much the data privacy part, but more of the design features, those things that you're making companies your compelling speech. That's always a slippery slope.
Mhm.
But there's a way I think to do it. And it's a matter of this might be it. I don't know. You'll hear from people who say that it is, people that say it's not. I'll try my best to keep
No,
keep my own wishes out of the.
I appreciate that. Probably more because with the Senator Eagle said, he's a media, people have a media company or has a media company and they will have an online presence and they may have,
You don't.
and they may have a promotion that they're doing and they go through the safeguards of checking everything, every box that they have, but the kid goes on their parents' computer. So the IP addresses to their parents and they put a date of birth that is an adult date of birth. And so, because prior to this, protect, but there is a bit of.
Well, what it gets into, Senator Major, is that, and I like the counselor answer, he was Switzerland, but that's what he's supposed to do, is that, well, the company should have known. The company should have known here. The company should have known there. And once they bypass that protection, the company should have known. The company should have known. Well, they don't know. But anyways, again, so those are the things that I'll be looking at. I can tell you as moving forward.
Yeah.
Those will be the questions I'm gonna be asking about, as we move forward.
There's
And
an
you
interesting
should.
part in there
Right.
that talks about basically making it I guess, mechanisms to help businesses know if they have.
If they've done
But
everything.
you know how you attorneys are.
I know how we are.
Yeah, and I hope we can get really specific about examples.
Yeah.
Yeah.
And just be not,
No, let's
I
tear it
mean,
apart.
we got the theory, but we gotta look at real
Tear it apart.
life.
Let's not be, you know, as we've said in our other committee, we want both sides of it. We want to hear it and we gotta tear it apart.
Oh,
It
yeah,
can't be, you know, not, and again, this can't be political. This needs to be public safety. And it's not like, okay, we gotta pass a bill about, no, we gotta look at it and make sure we get it right. Because this is big stuff.
definitely. And I think we have a good committee to do that.
Yeah.
All of our backgrounds are,
I agree with all
yeah, good. Well, thank you so much for being
that.
here.
Sure. Yeah.
Thank you, Rick.
Yes.
Thanks for listening.
Thank you.
And I think we're good. Are we-
Yeah.
Okay, so we'll see you all tomorrow. We are adjourned.